Yes.
Major Lordship, Lordship, I beg to mention item number 10. Lordship, am I allowed to withdraw this case?
The prayer of Mr. Lawrence,
One submit.
petition is dismissed as withdrawn.
I have another prayer regarding item number 36. Lordship, here, Lordship, I am on interim bail. Lordship, perhaps Kejari has not come. Lordship.
One number?
36.
You did not receive
I'm not
the
receiving
reminder
that case, right?
first. Continue. Next, list again.
Interim may continue.
Yeah, Lordship.
Highly-
Yeah, Lordship, Sarsit submit.
Interim may extend. Lordship, I will approach the court.
Can we dispose of?
Huh?
Then may be disposed of.
Well, then let it come up. You don't mention now.
May it please your lordship. But I beg to mention item number 41, my lord. Here, my FSL report, my lord, I have informed, my lord, FSL report is not present, my lord. So another date may be given, my lord.
41 FSL
Did you receive?
report. CD received,
Did you receive?
but FSL report is not received. List again on truants. Any
Wrong
interim?
date may be given, my lord.
Interim is there.
Interim is there.
Interim order passed. Let's continue. Next date.
My pleasure also.
Oblige, your lord.
In connection to item number 49, my lord,
Hmm.
there is an IA, my lord, already numbered, my lord. It may be brought on record, my lord.
May I please, your lordship? I beg to mention item 37, my lord. We are going to file additional affidavit, my lord. 1 week, after 1 week, my lord.
You have received the case there.
CD received on the prayer of learned counsel for the petitioner. List again on
Interim may be continued, my lord.
interim order passed earlier. To
My lord,
continue.
another prayer, my lord. In item number 56, my lord, we have already filed additional affidavit. So it may be bring to record, my lord, kindly, my lord. Hello, bless. Hello.
May I please, your lordship? I beg to mention item 24, lordship. On instruction, I may be allowed to withdraw the
All right. The prayer of pursuance. Your name
S.H. Raman.
dismissed as withdrawn. This is item number
24. Obliged.
May I please, your lordship, my lord, I beg to mention item number 55 of supplementary list, my lord, with the consent of other party, my lord. Kindly adjourn the matter for that day.
item number 55 on the prayer of
Date may be fixed. I am for the petitioner, my lord. Just come on.
learned counsel for the respondent and with the consent of the petitioner. Place the matter again on. Hmm? No more listings in November. Yes.
Please, your lordship, beg to item number 35. He allowed withdraw.
Withdraw. Okay.
There
Mr.
was an
Burman.
interim order.
Interim order. Dismissed as withdrawn. Interim order passed earlier. Stands vacated.
Lordship, another prayer with respect to item number 48, your lordship.
This was item number previous one 35.
35, your lordship.
Yes. Now
Now, item 48, your lordship. We have taken fresh steps. Your lordship. Report is awaited, your lordship. Maybe listed after 3 for report.
48.
48, your lordship.
Petitioner submits
3
that
weeks for report.
Learned counsel of petitioner submits that fresh steps have been taken. Await service. List again on. Give the date. Yes.
May I please, lordship, my lord? I beg to mention item number 6, 1, 9 and 21, my lord.
6,
No, 1, 9 and 21, my lord.
1, 9.
And 21, my lord.
Yes. What is the prayer?
This madam kindly passed over the day, my lord.
Passed over for the day.
Similar prayer for item number 2 and 3, my lord.
Okay.
You have received the case right in this. Keep the case right.
In 2 and 3.
23% by then FIR 21. You have received the case and 41 also. Just started.
CD all in all the right CD received may be retained till the next date. List
Obliged.
again on.
The lord.
Yes. Pardon?
26, Your Lordship.
Yes.
We adjourn for the date.
We have
Prayer-
received the case diary and
On the prayer of learned counsel for the petitioner, list the matter again on. CD received be retained till then.
May it please your lordship, my lord. I have another mention, my lord, item number 38, my lord, I've been informed final report has been submitted, my lord.
Withdraw.
My lord, as the final report has been submitted, interim order was there, my lord.
So what is to be done now?
I submit.
FR is submitted, my
Withdraw then. Or
lord.
it doesn't lie now.
No, my lord, withdraw, my lord, but kindly, my lord. FR
Item number
date-
30, it is submitted that IO has submitted FR in this case. Hence, nothing survives for adjudication. Matter is dismissed as infructuous. Interim order passed earlier, stands vacated accordingly.
I have FR number 35, 25, 39, 25.
30.
30, FR number is 35, 25, dated 39, 25.
Oblige your lordship.
May I believe? First, 30 on. Kindly pass over for the date.
30, 13,
31.
51. Give a date.
31, Lordship, with check it. Vote well.
CD receive be retained till then.
Lordship, I am appearing on behalf of yes, item number 30. Lordship.
30?
Not able.
30.
Already mentioned. 30 is already mentioned by somebody. I think. Is it? No,
31 is mentioned.
31
Is an interim, Lordship. Long date 30.
already. Interim passed earlier to continue till next. Yes.
Four 83 application, my lord. I take your lordship, FIR space 13. But what happened? A truck loaded with fish from Andhra Pradesh was going to Silchar. But the driver Dulal Das, who has done mischief, my lord, he has sold out the fish in a Dangtol Bongaigaon area. Under the pretext that his vehicle has been broke down, so fish will be rotten, so he wants to sell it. And this person, there are several fishermen of Bongaigaon area, they fasted the fish. And my lord, all of them have been allowed on bail, but this man, because of poverty, and he could not come up, my lord. Last 6 months, he's behind the bar. Case has been charged sheeted under section 417, my lord. Theft, my lord. So, my lord, I pray that he will regularly attend the court, my lord, face the trial, my lord, and he may be allowed on bail, my lord.
6 months.
6 months from 11/5/25.
Read hard learned counsel for the petition. The additional PP. This is an application. The allegation as reflected in the FIR is that the petitioner was the driver of a truck carrying 300 boxes of fish, which he unloaded during transit and sold the fish to nearby people. Para. It is submitted that the remaining other co-accused have been already granted bail. This one, page 34.
Best time, Honorable High Court has granted the bail. Say other co-accused.
Bail. By the order dated 25/9/25 in bail application 3037 of 25. Further, the petitioner has already spent 6 months, about 6 months behind bars, and charge sheet has already been submitted. Para. Considering the above, it is provided the prayer for bail is allowed. And so shall be released on bill of rupees 30,000. Once security of like amount,
CJM Bongaigaon, my lord.
Regime Bongaigaon.
PSA case number 12925. Arising out
Then
of the Bongaigaon PS case
can you
number
go to
1320.
Case 35 condition 8 para 8 9 10 para 8 9 10 of page 35 order to Zekulu. Yes.
Biplab.
May I pray, your Lordship? Lordship, this is an application praying for regular. Lordship, the FIR, your Lordship, will find that page 12. The relevant is page 15, Lordship. The incident with Pamuni Madam, the person was mob lynched. But in fact, your Lordship has granted bail on 7th of the persons who were arrested.
For that. KGMT hospital. What is your name?
M. Das. Lordship, the case
You are
diary
the
will be
main
available.
accused, I think.
Case diary may be available, you can
That,
verify.
Lordship, probably Lordship last week.
On 7/11, Lordship has granted.
CDs or with house office, but we have to take instruction whether CDs here or not.
Lordship can be taken up at 2, Lordship. Let him verify.
All right, you get the case diary, we'll see. Get the instruction in the meantime.
At 2 p.m, Lordship.
What is your name? M. Das.
M. Das.
We'll see.
Lordship at 2, Lordship. Obliged, Lordship.
Maybe before, we don't know.
May I please the Lordship? Regular bail application, FIR at page number 10, 8, my lord. FIR is start, my lord, under section 108 of BNS for mandatory period is 60 days. Now, in this case, my lord, today 73 days. Petitioner is not FIR name accused.
Item 6 of the order holding. This is item 7. 6 was time being. This time being the 2, which one was that?
Ramprasad Mondal no.
7. Okay, yes.
Lordship, FIR at page number 8. Petitioner is not a FIR name accused person. Lord. The whole submission is that on 15/8/2025 at about 4 p.m. the accused number 1 along with co-accused person physically assaulted the informant's married daughter, namely so-and-so, and driven out from their house. Finding no alternative, the informant's daughter committed suicide by hanging herself from a tree in front of the house of the accused. The allegation, my lord, I am not the FIR name person. This is my wife. He along with the accused number 1. Thereafter, he committed suicide in front of the house of the FIR has been registered 10 under section 108 for which 60 days is mandatory period. Now I am 73 days behind the bar. Page 16, the rejection order of the trial court. Trial court reject, my lord, earlier, my lord.
So it is 103.
108. 103 was not.
Mhm.
But later on,
What is the allegation? Basically, where is the FIR? Page 18.
8.
8.
Question is that, my lord, FIR name accused person assaulted the daughter of the informant. Thereafter, she committed suicide of the house of the accused. I am not the FIR name. This is my
But
wife.
the order of the magistrate doesn't make it look like a hanging.
PM was done later on. After that,
Several injuries were found, it seems.
injuries were
We'll
performed.
have the CD.
But to the 73 days might be.
What if
Mandatory
it,
period is over.
no,
Section may be added.
maybe added also. What will you gain? Suppose we grant you under 108 and 103 comes, you will not be released.
My information, no section.
There is time. Let's see.
But it may be 26/11. Let it know. So let's go.
May I please, your lordship? The allegation, three, my lord. The case that, only for petition number 3 and 4, I will pay, my lord. Can you see the FIR once? Page 11, the entire family has been named. my lord. But second line, my lord, Rajesh Kumar Rai, Mukesh Rai, Kuntara Rai, Vishal Kumar, Sunita Devi and Kajal Devi. Sunita Devi and Kajal Devi are the wives. The entire family has been arrested. There's a property dispute, my lord, and specific allegation is there, my lord. Can you see page 11, my lord? Not around 9 p.m., the aforesaid accused persons entered into quarrel over the issue of road and rebuked with filthy language. At that moment, the said quarrel, the aforementioned Mukesh Rai, Mukesh Rai's petition number 1, my lord, assaulted my elder sister-in-law, namely Sita Devi. She unfortunately passed away, my lord. The big bamboo stick and caused grievous injury on her head, and thereafter Mukesh Rai, along with the aforementioned accused, chased my father-in-law Suresh Rai and mercilessly assaulted him, meaning all the persons. But you kindly see, my lord, only 103 is there, my lord. No 117 or 118. Only humbly pray for him, only the petition number 3 and 4, my lord. They have minor children.
No, as of today, how do we know you are not involved?
The entire family has been arrested, my lord. The entire family has been named, my lord. Boundary dispute, my lord. Petition number 1 is clearly mentioned, my lord, that he did the overt act of hitting on the head, my lord. And when we produce to the next court
The
below,
grounds of arrest, it is said that the,
Yes.
with a common intention, accused persons physically assaulted the victim in connection with the ongoing dispute.
in the grounds of arrest also, my lord.
As of
Specific
today,
act-
we cannot say.
Specific act is on petition number 1, my lord.
It also says it has been prima facie established that accused persons, namely Mukesh, Kuntara, Kajal, Sunita, Vishal, were directly involved in the violent physical. CD,
So 3 and 4, my lord.
along with PM report. Yes.
27/11.
Oblige, my lord. Aye, my lord.
May I please, your lord. Your lordship, fire dated 16/7/2025. Relevant page 13, your lord. And in this regard, your lordship, today is the 114 days. The petitioners are written behind the bar, and similarly, accused persons were allowed to go on bail by your lordship by order dated 6/11/2025. Already charge sheeted, your lordship.
What is your name?
MH Borbi. My name is Sirajul Islam of
Who are you?
Secondary.
You are one of those 5-6 persons.
Yes, your lord. All the other co-accused persons were enlarged on bail, and one of them were released on bail by order dated 19/9/2025, prior to filing the charge sheet by the Honorable Court, your lordship, and that has been annexed in Annex of 5, page 26. That is a certified copy, your lordship. Mohor Ali alias Mohor Ali.
Date of arrest is same.
Same. My date of arrest is 21/7/2025. And since then, the petitioners are written behind the bar, your lord.
How many petitioners?
2.
Same order.
Sirajul Islam and Sekandar Ali, your lordship.
Same order date to চেঞ্জ কৰি দিছো ইয়াতে দুজন আছে প্লুৰেল
Highly appreciated. a 73 years old man been in jail for last 44 days. And your lordship, my lord, disposed of a co-accused bail application. Page, my lord, 17 and 19. My name is not in the FIR. But just perhaps
Who are you? What is your role in that?
I have no role, my lord. My role, my lord, I was just picked up. Perhaps, my lord, I was present in the village trial just as a spectator, my lord, as a villager. I was present, my lord, just as a spectator, because it was held nearby my home.
All others have been granted bail.
Granted bail, my in fact, my lord, they are not the my lord offender, man. They are
What is your date of arrest?
my date was 13/9/2025.
So how many days now?
44 days.
Okay.
I have
Same order,
narrated.
page 19. Same order. 19. Order dated 7/11/2025.
Obliged.
It is available.
Not recipient. Until he was called.
He did not receive.
It's not even in time.
List again on so and so interim order passed earlier to continue the next day.
Okay.
Right, please, your lordship. Lord, an application for pre-arrest bail. Lord, before I start, your lordship, kindly see petition number 5 and 6. In 2, 5 and 6, in the meantime, my lord, they have arrested. We filed this application on 7/11 and they were arrested on 9/11/2025. So for
Number.
2, petition number Saurabh Deb, then 5, Ritarani Deb, then 6, Archana Rani Deb. So far, these
2, 2, 4 and 6.
2, 5 and 6.
5 and 6.
So far, this petition is concerned, it has been become infractual. So far pre-arrest bail. Now, my lord, I will take your lordships at page 33. My lord, we are the victim. The assailant is the other side. Your lordship will find the FIR which we filed prior in time. That your lordship will find at page 33. The content starts from page 34. Lordship got it.
What is the date of lodging of your FIR?
That is on 310. At page 35, your lordship will get. The earlier one is the other side they filed on 410. Just a counter blast. Now, my lord, if I take your lordship the contents of the FIR, it read like this. I have the honor to state that around 10 p.m. on 10/2025, while I, along with my mother Rita Rani Deb, father Shant Dev, brother Subrata Dev, coming back from the house of my uncle after attending invitations, the accused persons in a body started attacking us by means of sharp weapons and lathi, all on a sudden being an earlier grudge. So they had plenty of cases, civil as well as criminal.
Where is the FIR of this case now?
Yes, the FIR of this case your lordship will find at page 9. Page 14, mate.
14?
Effectively, your lordship kindly come to page 22. It start at page 23. So I have the honor to state that so and so, we came back from Vijayadashami and slept at home. Around 11 p.m., the accused persons came armed with sharp weapons illegally and entered our house and called us. Just in the reverse way, it's a replica of the earlier FIR.
out of simplicity, when we came out, the accused person started hurling abuse at us without any remedy. Told me, assaulted my husband, son, Samrat Dev, and thus caused grievous injury to them. When I screamed, my neighbors, Sanjeev Ghosh, Prabhat Das, and persons came to save us.
But the person died.
Yes,
One person died.
one person died.
You will have the city.
Is there-
Now, my lord, if your lordship look at the papers which I have annexed, my lord, we are the main victim. Your lordship will find from the medical report at page 40 onwards. And the police is not doing anything against them. My lord, if your lordship look at page 48, is the petition number 4. Your lordship can see the photo. This is petition number 4. Then at page 49, petition number 3. Then again at page 50, petition number 1. They are seriously and grievously injured. Nonetheless, my lord, police is doing nothing because the husband of the informant is a very influential person, my lord, and he has a very good access to the corridors of power. And therefore, my lord, the police is silent, they are doing nothing, and they file the FIR, which is a counterplus to this. And the language used in the FIR dated 410 is just a replica of our FIR. And it is expected, my lord, when such type of injury they have sustained, the police ought to have done something so far the other accusers concerned.
We are not on that now.
Yes, I understand, my lord, but then I'm just trying to persuade your lordship that the police should not be doing some in a biased manner. And then so far we are concerned, my lord, they called, if your lordship look at our, fire, the lordship will find they took us in their courtyard, they beaten up badly, and we sustained the injuries we have that we have shown to your lordship. And that way, my lord, we are the victim and they are the assailants. Then they filed this FIR, showing that, my lord, they want to say that is an under section 189. So far unlawful assembly is concerned, it is not attracted at all. And if your lordship look at 1032, your lordship kindly see for a while.
Yeah, read.
103, my lord, your lordship kindly see 1032. When a group of 5 or more persons acting in
PNS.
concert commits murder on the ground of race, caste, or community, sex, place of birth, language, personal belief, or any other similar grounds, member of such shall be punished with death. Now the question would be, if your lordship look at our affidavit, initially, my lord, 2, then 4, afterwards, my lord, it doesn't attract 189 or 1032. So therefore, even on the perusal of these, my lord, the sections, the ingredients set out not at all attractive. So at this stage, my lord, what I pray that your lordship
Is
can,
any other ground?
my lord,
Any other ground?
these are the primary grounds. Your lordship, if your lordship look at both the FIR,
Had it been a case of grievous injury only, then we would have
yes, previous.
considered, but since
Lordship, your lordship can.
death has been caused, this is an anticipatory bail application without seeing the CD.
My lord, if your lordship look
possible.
at page 45 onwards, the CT scan on that,
Yes.
that gives an
It
indication.
might have been, you might have sustained injury in the course of the fight, but at the same time,
So now what I submit, my lord,
it's difficult to
if your
come
lordship
into.
grants interim bail, my lord, if your lordship finds after calling the case diary and if your lordship finds certain things, lordship may cancel that. And I believe, my lord, the case diary has been called in a similar case on 14th. So on 14th, it may be tagged along with that case.
This 14,
This 14th, coming 14th.
Or take on that case notes.
Hmm?
14, like if the case diary comes, lordship will consider after appraisal of the case diary.
today is 13,
Today is 12.
12.
Well,
The day after tomorrow.
yes,
What interim protection is required for that?
your lordship finds the materials on case diary, your lordship may cancel it.
For 3 days,
What will happen, my lord? Your lordship, see 3 of the persons they have already arrested. And they are, my lord, for the.
All right, since it is 3 days, we'll protect them for 3 days. Heard Mr. S. Dr. Learned, Senior Counsel for the petitioner. Also heard Learned Additional PP. It is submitted that the case diary of this case has been called in connection with another bail application being
Number of
I'll just keep, the lordship can dictate the
so
order.
and so, which is fixed on 14,
Yes.
11/25. Accordingly, list this matter along with the same number bail petition number
I'll give the number.
on 14. In the meantime, no coercive action shall be taken against petitioners till the next date.
I'll just find out the number and I'll.
Yes.
SI of police, my lord, that is from outpost of Suluni, my lord, lodged the FIR for the Suluni police station, my lord, alleging that he and his staff, my lord, conducted a search operation, and from the FIR name accused persons, my lord, some article was recovered. This is related to fake currency, my lord. And present petitioner, my lord, he is not named in the FIR. But police searching him, my lord, on that ground that the FIR name accused person, my lord, he is a person, my lord, who.
I will have the CD.
Yes. দেখা আছে সব কিমান আছে I'm hopeless.
Yeah, the lordship, 482 application lordship. The petitioners, they are the mother and brother of the main accused lordship. Sorry, lordship, and at page 10, page 14. Actually, Sanjay Tamali, he has already been arrested. He is the nodal officer of Fishery Mission Society, and he has misrepresented some amount of.
Where is the FIR?
FIR is page 14. And he has been arrested. Sanjay Tamali has been arrested. May I read, lordship? With reference to the subject and above, it is to inform that fine fraud, fraudulent, criminal conspiracy is supposed to be committed by Sanjay Tamuli, the Sub-Divisional Fisheries Development Officer, so under District Fisheries Development Officer, Establishment of Kamru, who acted as nodal officer of the Fishery Mission Society, Chief Minister Samagro Gramya Unnayan Yojana scheme. Sanjay Tamuli is connivances associated with Vijay Tamuli Fukan Srimoti. Vijay Tamuli is the brother. Srimoti Dipali Fukan is the mother, and one Love Roy, on whose accounts an amount of so and so amount was found to be transferred to their account from the account of Fishery Mission Society without knowledge of the undersigned, along with the financial advisor, Vaishnavi Devi, forging her signature. The said anomaly was detected by August so and so after receiving bank details statements. So this is the allegation.
So you were FIR named?
FNF. But Madras of her, her account has been operated by him. So she is not aware, she is totally in dark that those amount came from Fishery Mission Society. He used to operate. So far, mother is concerned, lawsuit will kindly protect the brother, your lawsuit may not protect. Because he is not, he is above 60 years old. Because as a son, he used to operate her account. Sanjay Tamul. So she is not aware where the money came from, whether it is from Mission Society or from some other investor. So far, lady is concerned that your lawsuit will protect. For the other brother, I am not praying.
I heard learned counsel for petitioner, read me additional people. Defrauding the Fishery Mission Society of us sum. By transferring a large sum of money, approximately rupees 264,48160 by the present petitioners, one of whom, that is staying the operation of the impugned judgment and order dated 23/10/24 passed by the learned Principal Judge, Family Court Number 3, Kamrup M, Guwahati, in FC Criminal Case Number 76/2020 is hereby vacated.
Lordships. My apologies, Lord. I was on legs in another court.
We have passed the order. You have not deposited.
Lordship, we have deposited. We have
Where
brought
is the
something-
proof? Monthly?
Lordship, there was a direction of this court to deposit a sum of 1 lakh. So that we have deposited. Lordship.
What about the
It is in
10,000?
register. Lordship,
What about the monthly 10,000?
that I'll have to take instruction.
No, you have not. You were supposed to provide proof. We have vacated the order. List again after 4 weeks.
Lordship may direct them to furnish me a copy of the petition, my lord.
It is, you have not furnished.
I'll have the instruction. This is a transfer brief. Lordship,
All right,
I
we'll
will send the
reconsider the
Lordship.
prayer. If you can submit proof.
Lord, I'll just take the instruction and come back, Lord. For the timing, because I just have to take the instruction, Lordship, and that 10,000, Lordship, probably that has been.
10,000 not paid, man.
Lordship, I have the instruction,
He has the instruction.
Lordship, my counsel, my lord, that this is a transfer brief. Lord.
Okay, go and come back.
Lordship. May have it after some time, Lordship. I'll
Yes,
just take
yes,
the
you come back with the, you come back with the proof, not instruction.
Definitely. Lordship will have it on a short date then, Lord.
Not short date, today itself,
Lordship today too,
after some time.
after some. I'll
Tell
just,
your client to run with the proof.
Lordship, definitely. Obliged, Lordship. Obliged.
CD not received, Lordship. IO is transferred, Lordship.
One submission can I make, my lord? In this case, my lord, it's a regular bail, my lord. In this petitioner had 5 number of cases, my lord. Due to medical urgency, my lord, interim bail was granted, my lord, in this case. There are 4 other cases, my lord, also listed other coordinate bench, my lord. So my operation is scheduled today, my lord. So I was asked to surrender on 21st of this. That interim order shall continue till 20. And the matter,
All right, CD not received. Interim order passed earlier shall continue till
21st.
21st of 21/11/25. List again on
On 25, my lord. On other cases are fixed on 25. My lord.
Okay.
Sorry, 26.
26.
20. And my lord, it may be listed along with my lord. Year number 3375 of 20.
List again. Along with
I'm obliged.
May it please your lordship. 483 regular bail application. Lordship, charge sheet was filed and trial court records were called.
Yes, where's the FIR?
Your lordship, the FIR is at page number. Already 101 days behind the parcel lady. May I read the FIR, Lord? Page number 11.
Yes, what is in the charge sheet?
Lordship, my lord, they have assaulted my lord, and my lord, ultimately, my lord, a pregnancy was terminated. My lord. And charge also framed, my lord, under section 329, 118, and 351 of PNS. Take the victim examine, my lord.
Let me submit with regards to the entire medical record. Will clarify the entire case.
There is no mention of abortion in that.
Indeed, your lordship. That is the main crux of the matter.
There is a, my lord, one,
I
Yeah,
there is
Your
one
lordship.
report, my lord, the scan copy, my lord. And also page number 36, my lord. Page number 36 of the bail application.
yes.
Your lordship, the FIR was
submitted on 29th of July 2025. In the FIR, the informant has only mentioned that she was physically attacked due to a banana dispute with regards to peeling bananas from their own tree, Your Lordship, with regards to a civil dispute nature with regards to boundary and property, Your Lordship. Thereafter, Your Lordship, the first time in the entire FIR, there is nothing mentioned about miscarriage or nothing mentioned with regards to any kind of abortion, Your Lordship. It comes up in the forwarding, Your Lordship. Your Lordship may kindly come to page number 16A, Your Lordship, the forwarding, where the entire issue of miscarriage or abortion first came up here. Page number 16.
Charge has also been framed.
Charges have already been framed.
Let the victim examine, my lord.
There is no charge of causing abortion.
Indeed.
It is not there, my lord,
Charge has not been framed under.
my lord.
So there, it appears there is no evidence that time of the counsel for the petition has done LPP. ACR is called for, has been received. There is an application under. and It appears that pursuant to filing of the charge sheet, the learned CJM Ojai has framed charge against the accused persons under section 329 3 ENS read with section 3 within bracket 5 ENS involving criminal trespass and under section 118 within bracket 2 stroke section 3 within bracket 5 ENS involving causing of previous hurt with sharp weapon and also under section 351 within bracket 2 stroke 3 within bracket 5 ENS involving criminal intimidation to cause death. To stop. However, although it has been alleged that due to the attack, abortion was the victim suffered miscarriage, as stated in the forwarding report. No charge has been framed under the corresponding provision. Which prima facie indicates that there is no material as far as causing abortion, material against the accused person causing abortion, causing miscarriage of the victim. The perusal of the FIR also indicates the same. Full stop. Having regard to the fact that the accused person who are women have spent about
101 days.
101 days behind bars, and the charge sheet has already, charges have already been framed. The prayer for bail is allowed. 20,000 on security. Satisfaction of CSM Hoja. It is provided the petitioner shall cooperate with the, they shall regularly appear at the trial.
Much obliged.
Studio was called for my.
We have received the case, but opinion because of this is pending, but FSL report not received yet.
My lord, already my lord, more than 2 months, my lord. 2 months, 4 days.
PM report is there.
PM report is here, but opinion is pending regarding what.
What is the allegation?
My lord, allegation, Lordship may kindly see page 14 is the FIR, man. Allegation that he helped to dispose of a dead body who was killed by one, my lord, Rafiqul Islam. Main accused the Rafiqul Islam.
The thing is that in ligation mark not detect. There is reddish black coloration of skin with a pale band in anterior aspect of corresponding skin crease. Otherwise, why accused is implicated? The petitioner that he has helped to destroy the body. Body was thrown out in a river later on.
His role is limited to
Help the
dispose of the
yeah,
body,
dispose of the body.
not in the main act.
Not in the main case, but who did it? That is not reflected in the case.
Mhm.
Who did it? The offense was it? That is not reflected from the case statement of the witness and other statements. So
And another ground, my
cause
lord,
of death is
ground
still pending.
ground of arrest, I have taken another point, ground of arrest, which was not properly met as per Supreme Court. My lord.
Yesterday, he was told that the disease has got suicide by hanging in a rope, lordship, and therefore he helped him dispose the body, lordship. That part is here.
Ligature mark is not found.
Lordship, ligation was not detected as per PM report.
But any other injury?
Injury and death not applicable.
Hmm?
No injury seen in here, lordship, but body was fully decomposed. That's why that is all parts are partially decomposed. That is very difficult to assert in the injury marks, lordship. One here, lordship, on dissection the tissue over the anterior border of right sternocleidomastoid muscle shows contusion of size 3 centimeter into 2 centimeter at a level of light lateral corona, the thyroid cartilage. So contusion was there. So wait for some time, lordship, till the receipt of the opinion, final opinion of the cause of death. Witnesses and co-accused statements has reflected, yes, his role is there to help the destroy the body.
He was a labor. Is some
No, you say that there is no material in the CD to show that the present accused had caused the death of the deceased, but only to dispose of the body.
Yes.
So even if the cause of death is found
Lordship.
after viscera analysis, then also things remain the same.
Same.
So, Third learned counsel for the petition. Third learned additional PP application under so and the allegation. What is the present petitioner's name?
My lord, his name is
Hamidul Rahman.
Hafizur.
Hamidul.
Eh?
Hamidul.
Hamidul Rahman.
Hamidul. The allegation against the present petitioner as reflected in the grounds of arrest contained in the notice under section 47 BNSS is that in course of investigation, it was found in substance that the body of the victim was disposed of by him in a surreptitious manner at Osista River.
Lordship, I have one submission going to the statement of the main accused. He has stated that confessional statement, yes, he had hit by a rod. This is head, Lordship.
It is main accused.
Main accused. His name is Lordship Rafiqul Islam. Later on, he go to the downstairs and to have request to help Hamidul, Lordship.
Osista River, along with main accused Rafiqul Islam and others, to destroy evidence. Full stop. Para. Upon perusal of the CD, it is submitted by learned PP that the main accused Rafiqul Islam had confessed to killing the deceased. But as far as the present petitioner is concerned, the only material against him is that he helped the main accused in disposing of the body. And there is no other material to indicate that the present petitioner participated in the act committed by the main accused. Full stop. In the meantime, the petitioner has spent how many days? How many days in custody?
My lord, 64 days.
64 days in custody. Accordingly, in view of the above, the prayer for bail is allowed. 50,000. Once you're further provided that the petitioner shall cooperate with the investigation and shall not try influence or intimidate the witnesses in it. Will be then allowed at this. Then back the seat. Transferred.
No, Lordship, this matter was never investigated or handed over to NIA. But maybe during the registration of this case or during filing of the charge sheet, since it is a schedule offense under the NIA Act, maybe that is why this it has been that special NIA case. But if the Lordship may allow me 1 week time, I will verify in the headquarter also.
No. My lord, I have a notification. On the basis of this notification, it has been registered. Only basis.
I'll show it to him.
On the basis of this.
Lordship, here the governor of Assam is pleased to designate the court of session judge in Assam as special court under section 22 of NIA Act 2008. It doesn't mean that the case is hand over to National Investigation Agency. It may be registered as a special.
Before submitting something to the court, kindly go through it.
Yep.
It may even turn out to be your own birth certificate. So you get the instruction. Bharatdas Learned Counsel representing NIA submits that instructions are required to be obtained from the headquarters as to whether the case had been investigated by NIA. Hence list the matter again on 1 week. Showing the name of standing counsel NIA in the cause list.
Publish.
Did you not receive, Lordship?
Please, for a short date, if please just
All right, give a short date.
70.
Steady note. Please take.
I don't. Short date, 7,
All right, give it.
around 17th, Monday. 17th, kindly. 7. Kindly.
17 is next week.
Yes, ma'am. I'm deeply obliged, my lord.
Lordship, put it into application, Lordship.
Received.
Receive, Lordship.
Result is in page number 8, Lordship. The petitioner is the Lordship, friend of the co-accused, Lordship. Nor he received money, nor Lordship demanded money, Lordship. It was just asked to accompany him, Lordship, on that day, Lordship. Lordship, but the pay, Lordship, amount has been taken, Lordship, but on the previous day, Lordship, where the petitioner was not present, Lordship.
Novel way of collecting money.
Yes. Amount was received by this petitioner.
When the Azhar Lordship, Akram Ali received the money, Lordship. But Lordship, the petitioner went on the next day, Lordship. 20.
Ridul Islam.
Akram Ali was hired for doing some black magic to kill the name any Gitanjali Kolita.
What about this Gitanjali Kolita that he has been apprehended or what? Anything in the CD?
Not apprehended yet, Lordship. Akram Ali was apprehended.
What is the role of the present petitioner then?
He went to collect money, Lordship. Which then prisoners were out them public. Then he was apprehended by Lordship. His role is limited.
How many days?
1 days.
Third learned counsel for the petition. This is an app. Paragraph 3. The bail petition. It appears from the CD that there is some material against the petition as he allegedly accompanied the main accused Akram Ali to collect the money. Beyond that, there is no other material. In the meantime, petitioner has spent 21 days in custody. Having had therefore is allowed. Then once it's cooperate.
Okay.
In this case, first, charge sheet submitted, Lordship.
What is the case?
Yes, my lord, allegation against the petitioner that he has deposited some monies of the company regarding some different account. Some not in compliance with the official norm. That is the only allegation. I'm ready. Here, connect tab.
It is received.
Charge sheet submitted,
Oh,
Lordship.
sources. How many days? Territory is 60 days, I think.
Yes, ma'am.
60 days. You can see.
Ireland also. If it is an application under. Then go to page 19 of forwarding. If history. Is submitted by learned PP that Harshit Bhai PS number
Right, yes, number, Lordship. 257/25 dated 30/10/2025.
has already been submitted. The petition has been behind bar for 57 days. Command the very period of detention 6. No. Statutory party.
Day, ma'am.
Having to the period of detention, the fact of investigation culminating in the charge sheet. Further the petition. Has bank accounts must have been frozen.
Lordship.
Comma. More so at the bank account. Which the funds were have been frozen. Prayer. Hello. 60,000 security. Order provided the petition and face the trial regularly. Shall not try to influence manner. Instead allowed in
How much should?
50.
We have not received a case diary also.
It is 55 days though, from the date of arrest.
What is the allegation?
Was it FIR page 10? I read it a type copy. Was it the relevant person? I was waiting for my ride near Hotel Pidep below Bhanagor when one person came and started talking to me. Subsequently, two persons came and introduced themselves as police without uniform and started questioning me for talking to the first person. They asked me to come to police station, and in the meantime, they opened the hook of my gold chain that I was wearing and went away. This is the allegation.
How many days?
It's 55 days today from the date of arrest.
Yes, PP 55 days.
Not
Hard learned counsel for the petition. Hard additional PP. This is the
nothing.
the allegation as per the FIR is that the gold chain of the informant has been snatched away by a group of 3 unknown culprits in front of Satsang Bihar, Bhanagor, when the informant was waiting for his ride.
Yes, but that highway, right?
Near Hotel Tridep. By pretending to be police personnel. Whereas per the CDS called for has not been received. As per the forwarding report, it appears that the petitioner was arrested on suspicion. And in the meantime, he has already spent 55 days behind bars. The statutory period of being 60 days. It is expected that the investigation would have progressed during this period and having regard to the above para prayer bail is allowed. 3,001 same condition.
Available.
Model.
Made resolution. It's a regular bail application.
The pendants, my lord, the charge was submitted, was called for, my. What happened in this case, my lord, they are all from the same locality, my lord.
Hmm.
During that Bolbom, my lord, they all stay in Borkuria Gaon, my Romia, my under Romia police station.
Mhm.
The day that Bolbom, my lord, they went to a temple, my lord. All the, my lord, the person of that locality, they went, my lord, and is a fact, my lord, possibly they had, my lord, that alcohol. So, this, my lord, he did not accompany the other person to a temple, so he left. And this, all these petitioners, my lord, 8 accused persons, my lord, they came back to their home. That person, he left, but he didn't arrive. Now, whatever in the FIR, they state, wife, my lord, she states that, my lord, he was forcefully taken in the vehicle. Possibly that is not correct. If somebody is taken forcefully, my lord, page 17, my lord, kindly have a look. He says that he was taken forcefully. But in fact, they went all voluntarily, my lord. And if he was indeed taken forcefully, she would have immediately lost the FIR. My lord. And she suspects, my lord, that he was killed by this. And my lord, the scan copies, my lord, we have seen, my lord, and my learned colleague has also seen, my lord, they're all lines, my lord. I believe more Bisak that they have done it on that line. And here, what the investigating agent. All these persons, FIR was lodged on 4th. On 4th, they were arrested. On 5th, they were produced. Now they are in custody for 97 days. And what the investigation agency did, my lord, the FSL report was awaited, my lord, and they submitted charge sheet without completion of the investigation. That lordship find, my lord, we have annexed, my lord, the charge sheet, my lord. Now, my lord, in our application, my lord, page additional affidavit, page 40, lordship find, my lord, that the report was awaited, my lord. So, part charge sheet was submitted, and that possibly lordship knows, my lord, now that Ritu Chabaria case, my lord, that it is an incomplete charge sheet, my lord. And prior to 90 days, that charge sheet was filed only to frustrate their, my lord, that default date. Now, till date, as our instruction, my lord, no final charge sheet has been submitted. And the FSL report, my lord, the postmortem report, my lord, page 54 of our additional affidavit, my lord, that, my lord, that opinion regarding cause of death is kept pending till receipt of reports of chemical toxicological analysis from DFS Sahipara case. They will face the trial, my lord. All persons picked up, my lord, same locality. Face the trial.
What is the postmortem report?
Postmortem report of opinion is pending, but other part
Some laceration and, my lord, abrasions are there, my lord, page 53.
multiple abrasions of size 2 cm. Also abrasions are there, lacerations of there.
We have been provided with those copies, my lord, all we have annexed. 10 copies also. And its statement, I believe, more Bisak, more Bhabu.
If we kindly go through the. They have, you have submitted this.
We have also submitted, and it is 10 copies also. there.
Available with you.
Yes, sir.
And go through the evidence. The charge sheet has been submitted.
Only
Is there any direct implication, or most of it is hearsay, or?
charge sheet submitted on 25/10/25.
Yes. Would like to know what is the nature of the evidence collected. Please go through that. Take it after some.
After some time, my lord. Obliged.
We want to know if there is any direct implication, or it is just on the basis of.
Let him go through. I have
Hearsay.
also marked. Let him go
Yes.
through it, my lord. Obliged.
Yes. Yes.
I have perused the case diary, my lord. But this person, my lord, he was also present, my lord. And he also argued, my lord, with the deceased, my lord. Before the, my lord, quarrel took place, my lord. But regarding the assault part, my lord, his name has not been implicated directly.
You annex the earlier order.
Lordship, I have a copy.
There are a few eyewitnesses, my lord, whose statement has been recorded, my lord. They have not implicated him as far as the assault part is concerned.
What is the period of detention?
37 days to pay, Lord.
Same order.
Obliged, Lordship.
Only, my lord, think this matter has been come for motion column, my lord.
Oh.
Also, they mentioned in my lord, since the case diary was present, my lord, it was called for my. That may be. But in the motion column, my lord, we cannot produce the case diary.
CD is present in connection with earlier disposed of.
Earlier case, my lord, it was available in our office, my lord. So it was. They have produced the case diary.
In paragraph number 5, right? The CD of the case is available as it was submitted in connection with another bail petition disposed of earlier concerning the same. Justice.
Deeply obliged.
They had appeared, right? Follow up to some time.
Great reason. You were good contact. Keep the pass happen.
We have passed already.
Lots of. Obliged.
May I please, Your Worship. But PRS bailiff, it has been called for now. I am on interim, I have already been.
Received.
My lord, case diary not received, my lord.
CD notaries. Item 29. He did not tell him to continue. Please take a note.
112.
Interim order passed.
Till next date of. Received.
32 case diary not received.
The same order.
What's your name is guy?
P12. P12. The 33, my lord, search is submitted, my lord.
So what do you want to do?
Lordship, Lordship, the present case, my lord, that involves, my lord, out of an FIR, my lord, at each Lordship. So it's a cross case, Lordship. First, your Lordship, see the FIR, my lord, lodged by me, my lord.
What do you want to do now? Do you want to appear there and apply for regular bail, or should we call for the scanned copy of the charge?
My lord, I am on interim, my lord, I will appear before them, my lord, the trial. Otherwise, my lord,
Till them interim to continue.
Lordship.
Hmm?
Lordship,
You will apply for regular bail.
my lord. My lord, in fact, my lord, it is a cross case, my lord. Both the, my lord, accused and the
Yes, sir. That the interim to
lordship. I'll apply for the regular bail. Let the interim be continued, ma'am.
till his appearance.
Third learned counsel for the petitioner. Learned additional PP submits that charge sheet has been submitted
By charge sheet number 577/2025 dated 28/10/2020.
Right, lordship, there is a compromise
learned
between both the
counsel for
parties.
the petitioner submit that the petitioner shall appear before the court below and apply for regular bail. The then petition is disposed of the observation that in event of any such bail application being filed,
Yes, sir.
same shall be disposed of as per law. And before that you write, shall appear or let the petition appear on it below in a period of 15 days today. Till the date of his hearing, 15 days. today, the interim passed earlier and remaining force. It is of following.
I'm deeply applied.
Okay.
It is.
Here before the IO or
Lordship.
3-4 times.
His statement is recorded.
What is the allegation?
Page number 25. 11 14.
Yes, his statement has been recorded, but what, any material against him?
Yes.
Lordship, he is the proprietor of second-hand lordship dealership.
I was caused by the human regarding was called that by the forgery registration was transferred. Registration of it to that bike was
What is his statement?
Lordship, Lordship, he stated that I am the owner of MS Auto second-hand showroom, which I have been running for the last 10 years under a valid trade license. On 21/2020, while I was at my showroom, one person named Ashan Ali Sheikh come and inquired whether I purchased second-hand motorcycle. I replied, yes. Ashan Ali Sheikh stated that he had a motorcycle to sell as his wife was admitted in the hospital. Therefore, I purchased the said motorcycle from him for rupees 37,000 after executing a money receipt on a revenue stamp. At the time of purchase, Ashan Ali Sheikh submitted a laminated registration certificate and 2 photocopies in the name of Apurva Kumar Burman. Subsequently, on 24/1/2021, customer named Rafiqul Islam approached me to purchase the motorcycle. I sold it to him at price 40,000. On that day, before handing over the motorcycle, I called Ashan Ali Sheikh to sign in my register since I did not personally know Apurva Kumar Burman. Accordingly, Ashan Ali Sheikh signed the register, and therefore I sold the same motorcycle to Rafiqul Islam. Later, when I visited DTO office, Bongaigaon, I tried to initiate the ownership transfer in favor of Rafiqul Islam. I was informed that without ownership transfer, the purchaser would not accept the motorcycle. One staff member of the DTO office, Bongaigaon, with the help of the staff, facilitated the transfer process. I do not know who exactly was involved. On 6/8/25, Rafiqul Islam informed me that he had received a call from someone identifying himself as staff of DTO office, Bongaigaon, directing him to produce the vehicle bearing number so-and-so along with relevant documents. Rafiqul Islam then handed over his vehicle and RC to me. On 7/8/25, Ashan Ali Sheikh himself rode the said motorcycle to the DTO office, Bongaigaon, While I went there in my car along with Tamizur Rahman, Ashan Ali Sheikh parked the motorcycle in front of a DTO office and left for Dhubri. On his way back near Panbari Masjid, he handed over the key of the motorcycle to me, and I continued my journey to Bongaigaon. Upon reaching the DTO office, Bongaigaon, I noticed the motorcycle parked in front of the office. I handed over the key and registration certificate to the concerned authority. During physical verification conducted by the motor vehicle inspector, it was detected that the chassis number, engine number did not match. At that stage, DTO instructed that Rafiqul Islam should also be present.
All right, beyond that, anything else is there?
No, no.
So he does not appear to have been involved in the, at least as per the CD. Third learned concept, the petitioner, learned it's public security. This is an application of the term. Earlier, I had rejected one bill application, I think, in respect of the DTO official. The same FIR. The case of the allegation again.
Okay.
Learned petition, PP upon perusal of the, he submits that the petitioner had appeared pursuant to interim protection granted by this court, the petition had appeared before the IO and his statement has been recorded. There are perusal of the state statement, the involvement of the petitioner is not discernible, and there does not appear to be any other material CD implicating the present petition. Accordingly, the pre-arrest bail is allowed. Interim pre-arrest bail dated 29/8/25 is hereby made upon the following conditions. Dated section number 2 and 3. Order the effects to reflect the is this posted?
Wait, please, your lordship. Lordship, this,
Charge is submitted, Lord.
I'm on interim bail.
So will appear and apply for regular.
Yes.
Same order. Within 15 days. Till then, only till then you are protected.
Highly obliged.
Lordship, charge sheet number 192, 2025, dated 27/09/25.
Obliged.
CD received, Lordship.
Yes, what is that?
Lordship, as I had it, please, 7.
Who are the present petitioners?
Present petitioner, Lordship, accused number
Give the name.
and 4 and 5. Is number 4 and 5.
Chipula and
Lordship,
Parul.
Sapula and Paru.
Pula
Lordship, prime accused
Chipula
arrested.
Borvia Parul Islam
Lordship,
Loskor.
Islam.
Accused number 1 and 2 arrested, Lordship.
Yes,
Lordship, sufficient materials are there, Lordship, against this two petition, Lordship, and recovery of looted money, Lordship, to recover, Lordship. Their custodial interrogation is necessary, Lordship. And Lordship, the accused person are identified by the victim, witness during the investigation, Lordship, and they had committed the dacoity, Lordship, and the incident was not a simple theft, but organized, Lordship, organized crime, Lordship, and statement of co-accused, Lordship, also stated that how they, Lordship, committed the dacoity, Lord. Their names are also.
grant counsel for the petition. It is GP application. Application against the this present petitioner is that as they, along with the co-accused person, accosted the informant while he was returning to Mizoram after selling his ginger at Bhagabazar. And the accused person looted rupees 13 lakhs from him, which was the sale price for the ginger. Was perusal of PD, there appears to be incriminating materials against this person. It is further submitted by learned PP that their custodial interrogation necessary for recovery of the looted money. Having regard to the prayer for bail is rejected. Accordingly, can be CD.
Like.
May I please, Lord? My Lord, I am on interim.
Receive.
Is there receipt, my lord? There are sufficient materials, my lord, collected by the IOM against this person.
May kindly see the FIR. FIR is 17 minutes. Lord, page 17 is the FIR.
Petitioner's name is?
Imranul Latif Boruamal. My
Accused
Lord,
number
the
one.
informant.
Yes, we have read the FIR.
Hello. Now the allegation is that, my Lord, the land covered by dock number 140 and 243 of pattern number 37, my Lord. My Lord, pattern number 37, it includes, my Lord, lots of ducks. And this is a family property. Now, my Lord, informant is the younger sister of my grandfather, my Lord. So we are from the same family. So, may kindly see the allegation is that I have sold out the land, probably dock number 140 and 243 illegally. By, my Lord, obtaining my NOC certificate and from all other Patadar of our family. My Lord, regarding other Patadar, there is no objection. I don't know how he made this application. My Lord, kindly see
My lord, already in the Jamabandi, my name has been reflected along with my brothers and my sister, my lord, against my father, my lord. After the expiry of my father, my name has been mutated in this 140 and 243. My lord, I will show you them, my lord, in the Jamabandi, my lord. Plus, you may kindly come to page 61. Page 61, my lord.
Yes.
So, my lord, in page 61, my lord, kindly see serial number 344 and 345.
Hmm.
344 and 345, my lord. 345 is the name of the petitioner, Muhammad Imranul Latif Borua, Mito Daudul Latif Borua, his father name, and Mito Sufia Begum Borua, Mito Daudul Borua, is the name of the mother, my lord. And my lord, kindly see page number 108, my lord. What is 108?
Yes.
My lord, 108, my lord. Last remark in the remark column, my lord. In the last para, my lord. Hukum number 1. May I read, my lord?
Hmm.
হুকুম নম্বৰ 1 চক্ৰ বিষয়াৰ 25/7/2025 নামজাৰি নং ইমান তাৰিখৰ হুকুম মৰ্মে 140 ডাগৰ 0 বিঘা 3 কঠা লেচা মাটিত খৰিদাৰী সূত্ৰে ইমাম লতিফ বৰুৱাৰ লগত সুলেমান খাতুনৰ নামজাৰি কৰা হ'ল. It is after purchase. And my lord, subsequently in para 109, 242, my lord, 109, my lord. This is after sale, my lord, Namzari has been granted. And Lordship may kindly come.
109.
140 and 243, my allegation is against these two dark. And my lord, kindly see 105, my lord. This is the 105, my lord.
Yes.
This second para, 25/30/2024 তাৰিখৰ নামজাৰি হুকুম মতে 140 নং ডাগৰ মাটিত উত্তৰাধিকাৰী সূত্ৰে শ্ৰী দাউদুল বৰুৱাৰ সহস্থলত দাউদুল ইজ মাই ফাদাৰ, my lord. ইমৰানুল লতিফ বৰুৱাৰ পিতৃ সহিংস আৰু জুলি লতিফা বৰুৱা আৰু জুবি লতিফা বৰুৱাৰ নামজাৰি কৰা হ'ল. So it is against 140 after my father, my lord. Then even in the 140, 243 also, my lord. 243 is reflected in 103 case number. 103, my lord.
Hmm.
Does it got it, my lord? 103?
Yes.
103, my lord, last para. 20/9/2024 তাৰিখৰ হুকুম মতে 243 নং ডাগৰ মাটিত উত্তৰাধিকাৰী সূত্ৰে দাউদুল লতিফ বৰুৱাৰ সহস্থলত ইমৰানুল লতিফ বৰুৱাৰ পিতৃ দাউদুল লতিফ বৰুৱাৰ মিছ জুবি লতিফ বৰুৱাৰ আৰু মিছ জুলি বৰুৱাৰ নামজাৰি কৰা হ'ল. So my lord, it is after that of my father, my lord, in these two dark 140 and 243, my name and my sister names were already mutated. Now till date, the informant not objected to this mutation. Now I have sold my share of land, my lord. What is the illegality, my lord? And lordship may kindly see this informant, my lord. Her name is already reflected in this patta. Yes, she has also land in this patta, but not in this dark 140 or 243. My lord, we are a big family. It is ancestral property, my lord. I have got my share from my father.
Has it been partitioned?
No, my lord. I think, my lord, this already family settlement is done. All the patadars have separately, my lord, possessing their share, and always most of the patadars, my lord, sell out their land. All individual share.
Yes, so what is the material here?
He obtained a certificate, my lord, showing the person who were already alive, my lord, showing them as dead, my lord. He initially obtained the certificate from the Gambura, my lord. On the basis of that, my lord, he obtained NOC, my lord. After he sold the land. This is the material so far collected by the IO, my lord, and now it is pending for, my lord, FSL examination of the signature.
My lord, let them come FSL report, my lord, because regarding these two, I don't need any kind of documents from others, my lord. This is because in my name. Lordship, it is very clearly reflected that my name has been mutated after my death of my father, my lord. And Lordship may kindly see, I will show you the name of the, my lord, informant. Lordship may kind of,
According
paste-
to his submission, the land was mutated in his name after the death of his father. Now, whom has he shown as dead to sell the land?
yes.
My lord,
Who
these are
are
the
the
persons, my
persons who
lord.
have been
If-
shown as dead?
Even, my lord, the Gaumura, my lord, his statement also recorded, my lord. Even he also said, my lord, that they were not present, they were not, my lord, residents of that locality, my lord. They were not for more than, my lord, sufficient years. Then this accused person, my lord, he came to the Gaumura, my lord. He said that this person is already expired, my lord. That is why, my lord, the Gaumura issued the certificate. Gaumura has also committed, my lord, some mistake, my lord, because without verification, he issued the certificate.
My lord,
This
NOC.
is why he has also
So
been made
who
accused.
are these dead persons? They are the co-patadars.
Yes, my lord, they are the co-patadar, my lord.
My lord, in this patta, my lord, more than 35 dags are there. Already Lordship
These
may
are
kindly
matter
see.
of trial, my lord.
No, no,
How
that is
many
what
dark,
I'm saying, my
many
lord, that
pattas
is a
there?
matter of trial. But
These are
my lord,
matter of-
140 and 240
Now,
is
Lordship
exclusively
will
my
only go
land.
through the, my lord, prima facie
It is
materials
not
that they are
necessary.
unknown.
And my lord, as per instruction, my lord, from my client, till date, he already appeared twice before the IO, my lord, but his statement is not taken.
His statement recorded, my lord, it is in the case diary, my lord.
As per my instruction, my lord, from the client, my lord. And Lordship may kindly see, page number 24, my lord, IB Borrower name is already reflected in different dag. Now, Lordship, in 140 dag and 243, whether IB Borrower name is there, my lord. In that case only, I need the NOC from him, her, my lord. It is not required also from the other patadars, my lord. All are possessing their share of land. And it is very clear from 140 and 243, my lord. Only my name and my sister names are there.
Even Lordship, if Lordship goes by the statement of this accused person, Lordship will definitely reject his bail.
But till that, his statement is not taken.
It is taken, my- it is in the
You
case
pass
diary,
over
my
the
lord.
CD.
Already, my lord, I have appeared twice, my lord, before the IO, as per my instruction, my lord, from the client. But they are saying that you bring the record. He already stated before the IO that if you require the document, you bring it from the records, from the circle office.
Remember. Yes, next.
Obliged.
What is the case diary receipt?
CD received. None appears. Based after expected debit.
Case diary receipt, my lord.
It is by application, my lord. There are 16 petitioners before laws that belong to the family. Yeah, my lord, entrance is sparked off due to land dispute, my lord. It is a fighting between the two groups, my lord. At 9 p.m. at night, my lord, the interior paper place, my lord, blaze, my lord.
FIR is good.
And out of, my lord, we know that FIR initially that was registered as section, sorry, my lord, PS case number 72/2023. The FIR where now we are seeking bail, which is, my lord, PS case 73/2025, my lord. Against us, the FIR, my lord, page 14. Page 14, it is against us, my lord, wherein we are seeking bail, my lord. Yeah, says my lord, 6 person, my lord, had the disease just before his death. My lord uttered the name of 9 person out of 9, 3 already arrested. The 6, my lord, petition number 1 to 6. Since he, my lord, uttered the name, I'm not, I'm over the number 1 to 6, I'm leaving it to your lawful. For the rest of the petitions, my lord, he did not utter the name of the other petitioners. And he said, my lord, can you see next FIR, page, my lord, 22, my lord, it is lost by the daughter-in-law of the petitioner number 1. Actually, what happened on that particular day, my lord? Page 20 is a long FIR, my lord. Because it is arising of the land dispute, my lord, this informant side, they are trying to, my lord, encroach our land for last 3 years. And some plot has already been encroached. They initiated, my lord,
Title suit number, my lord, everything is discussed in this FIR, page 22, my lord. May I read, my lord? My lord, I'm starting from para 3, my lord.
Hmm?
The page 20 FIR lost by us, that is daughter-in-law of the petition number 1. Page 22. Para 2, my lord. Informant husband and the aforesaid Keat and Keen are stay at the same village accused as mentioned herein below. In the year 2020 enclosed plenty of land covered by so-and-so Doug number so-and-so. Situated as village Kalamdikas belonging to the informant father-in-law and this and Keen for which Abdul Qadir, petition number 1 Abdul Aziz, Gazibur Rahman and the Islamuddin Ahmed as mentioned above initiated title suit, being title suit number 4/2021 that is initiated by us against the informant side. The Court of the Learned Civil Justice Senior Division, Mongoldo, and in the said proceeding accused after being appeared in the case, after being appeared, the case is pending for evidence of plaintiff in the court. My lord. Next para. During the pendency of the aforesaid case, accused as mentioned herein below, armed with dao, pala, while making effort to occupy a plot of land measuring 8 biga 2 kata 7 lesser situated at village number 3, Kalandikas, under pattern number 66 and Doug number 114 and 120, which belongs to father-in-law, namely Gazibur Rahman, and uncle-in-law, namely late Abdul Aziz of the informant, for which the said Gazibur Rahman, Malika Khatun, wife of so-and-so, 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 against the accused person in the court of Learned, in the court of Learned Civil Justice Senior Division, Dorang, Mongol.
Anybody from the village left out?
Hello? Yes, my lord, yes. Father-in-law, namely Gazibur Rahman, uncle-in-law, namely late Abdul Aziz of the informant, for who is the said Gazibur Rahman, Malika Khatun, wife of late Abdul Aziz, Nizamuddin, son of late Abdul Aziz, Arfan Ali, son of late Abdul Aziz, Musa Kalimullah, son of late Abdul Aziz, Nabi Hussain, son of late Abdul Aziz, have initiated title suit in the year 2003, being title suit number 120 of 2003. It is initiated by us against the informant side. Miscase against the accused person in the court of Learned Civil Justice Senior Division, Dorang, Mongol. The said case being pending adjudication, accused mentioned herein below, once again while making effort to construct a house illegally occupying a plot of land measuring so-and-so at village Kalandikas under pattern number 63, Doug number 54, which belongs to informant's father-in-law, and Gazibur Rahman, Malika Khatun, wife of late Abdul Aziz, Nizamuddin, Musa Kalimullah, resulting the said Gazibur Rahman and the Malika Khatun, wife of late Abdul Aziz, have initiated title suit against the accused, being title suit number 1/2003, this case so-and-so against the accused person in the court of Learned Civil Justice Division, Mongol. During the pendency of the said case, accused as mentioned herein below, heads up a conspiracy by hiring some goons armed with lethal weapons, violating court's order, and during the pendency of the case, started making construction of house over the said land, occupying illegally, which belongs to informant father-in-law and his brother. Moreover, 6-7 months ago, from today, accused as mentioned herein below, hiring some goons, getting informant father-in-law and his brothers illegally occupying a plot of land, pattern number 64, Doug number 107, 106, 109, situated at village number 3, Glandikas, which are exclusive possession of the informant's father-in-law and his brothers constructed 13-14 numbers of houses and destroyed all maize cultivated over the said plot of land, which caused huge loss. Abdul Qadir kept on closing the several FIR against the accused time to time regarding the same incident. Apart from that,
Anything against the petitioners 7 to 12?
My lord, yes, my lord. Lordship may kindly come to page number 2, my lord. There is a
7 to 16, sorry.
no, page number. Lordship may kindly come to page number 2 of the bail application.
Yes.
Post title. Lordship may kindly see, my lord.
1 to 6 are all FIR named accused.
Yes, my lord. Against my lord, I have not found, my lord, as on today, my lord. Investigation is going on. 2, then my lord, 12, then 13, 14, 15, 16. Against this, my lord, I have not found, my lord, anything as on date, my lord. Although investigation is going on. 2, then my lord, 2-9. I'm sorry, my lord. 2-9, 12.
Abdul Ghaffar, Abu Safian.
Abdul Ghaffar, Abu Safian, Rizaul Karim, and Abdul Jalil, Ismail Hussain, Tahir Ali, Badr Ali. And apart from the others, my lord, from 1 to 11, my lord, there are materials, my lord. The eyewitnesses are also there, my lord. They have also implicated. And one person died, my lord, and several other person also.
Petition number 10 is concerned, my lord. He is pursuing, my lord. He is not present on that particular night, my lord. The day of, on the night of incident, my lord, because he was a student, he is pursuing his. profession.
Suleiman Bacha,
Suleiman Batsha, yes.
Yes, my
the
lord.
material is there against him.
Yes, yes, material is there.
He is pursuing, my lord, pharmacy course in the Hyderabad. Sinanath University, Hyderabad. On that particular night, my lord, he was not present, my lord. He was a student.
You say alibi, that means
So against this person, my lord, I have objections, my lord.
if you say you were elsewhere, then you have to show us something that you were not there. Because the material is against you. All right, hard learned counsel for the petitioner. Then application on so and so.
I have stated in para, my lord, regarding. So I have not enclosed any documents, my lord, but I stated, my lord. Para 8, my lord.
As per the FIR on 26/6/25 at around 8 p.m. The accused persons named therein attacked the informant side with deadly weapons due to quarrel arising out of land dispute. And as a result, grievous injuries were caused to the members of the informant side, and one among them succumbed to his injuries. Soon after the incident, and before his death, he implicated some of the petitioners as named in the FIR. Para. Learned counsel for the petitioner submits that there is long-standing land dispute between the parties, and the petitioner side had also lodged an FIR against the informant side of the present case, which has been annexed to the instant application.
Page 22.
Similar allegations of assault and causing of injury has been made in the said FIR lodged by the petitioner side. Learned additional PP on perusal of the CD submits that as regards petitioner number 2 Abdul Ghaffar, petitioner number 9 Abu Safian, petitioner number 12 Rezaul Karim, petitioner number 13, Abdul Jalil, petitioner number 14, Ismail Hussain, 15, Tahir Ali, 16, Badar Ali. There is no such incriminating material. However, there is sufficient incriminating material against remaining petition. Para view of the above and considering the gravity of the offense, the prayer for pre-arrest bail in respect of the aforesaid petitioners number, no, at that line, just like in view of the above, the prayer for pre-arrest bail in respect of petitioners number, the same ones are is allowed. Is however, in view of the incriminating material and gravity of the involved, the prayer for bail in respect of the remaining petitioners is rejected. Here is the bail, pre-arrest bail granted to the above named petition subject to the condition that they should cooperate with the litigation. Shall not try to intimidate, influence the witnesses in any manner. It is disposed of accordingly.
All right.
Your loss. That went to suicide, man. 10 year loss will find the affidavit. 23 years old, marriage was settled. So marriage allegation is that mother demanded some dowry. That's why she committed. Our cases, my daughter, she was to complete the graduation. Thereafter, marriage is to be solemn. They have actually decided to marry some other person who she did not like. Actually, she died on the pressure of the her own parent. Page 10 is there.
Yes, PP.
Yes, my lord, it is true, my lord, that the victim and the affair name accused number 1, my lord, they had love affairs. And their marriage was also arranged and fixed, my lord. But after that, my lord, the allegation is that, my lord, they demanded dowry, my lord. That victim could not come to her, my lord, parents, and later on she committed suicide. Is it the allegation?
Our case material also will find page 6, paragraph. Yeah, my daughter. Paragraph point of 4. 4, man. Fact, my daughter, to our information, her marriage was settled to some other person. Her brother is the main master. She wanted to not to be married to the present. Anyway, my daughter, what means suicide, your lordship knows, my daughter, that is very difficult to prove, my daughter. The very latest, just my daughter, for my only 2 small paragraph. This was decided on 27 October 25, paragraph 17 and 18. Very small paragraph.
Okay, pass over the CD.
My lord.
Yes, next.
Obliged.
Where base 50 on him.
Hmm.
Where base
Received.
Yes, that is my lord.
376.
Yes. In this, the land. Permit is the matter of use means law. Really. But comes
Speak a little louder if you want
both
us to
the
hear you.
agreement and the relatives. Permit is the material aunt of the accused law. There is a land dispositions law, taking care of land. A case meeting was, but no fruitful results comes up. Thereafter, the implement lost there by leveling some parcel. Yes, finally, the page 15. Now the accused is 32 years old, but as per APR, সে আজিৰ পৰা 4 বছৰ মান ধৰি এজাৰকাৰণীৰ পিতৃয়ে 1 নং আসামিক স্কুলত নামভৰ্তি কৰি পঢ়িবৰ বাবে নিজৰ ঘৰত ৰাখিছিল। That is at the age of 28 years.
What is the age of the girl?
So as per my lord, 183, my lord, 22 years.
Like 32 years.
Yes, sir.
But the informant have not mentioned about the date of
So my peruse are 164 statement.
It appears he was a major at the time of it started.
Major, my lord. The allegation is
Sari-
about love affairs and my
Sari
lord,
hat pass.
also my lord, she had abortion twice, my lord, as per her said. And later, my lord, refused to marry, my lord.
Heard learned counsel for the petition. Heard learned mediation. This is an application under influence as per the allegation made in the FIR. The victim, who is a major, was in a love affair with the accused person who promised to marry her, and they entered into a physical relationship which continued for a long time. However, subsequently the accused refused to marry the victim and started abusing and harassing CDS call for has been received. And I have perused the statement of victim recorded under section 164 CRPC. There is no allegation of any forceful sexual intercourse. The victim was currently had apparently attained maturity at the time such incident took. Having regard to the above, custodial interrogation petition is not deemed necessary. Accordingly, pre-arrest bail is allowed. 20,000 on security. Cooperate with the investigation.
Obliged.
Send back the 3D.
I have gone to the records, Lordship. In that case, 10 copy statement of the witnesses are not there, but accused statements are there. The honored counsel for the petitioner submitted some certified copies of the statement of the witnesses. Going to the statement of the witnesses, they have stated that some confrontation was there earlier on, Lordship, regarding a construction of a Anganwadi establishment, Lordship. But other than they have, they suspected that they might have killed that disease, Lordship. Other than the prima facie materials are not, eyewitness was not there. He was found lying on the dead body. The prima facie materials are not there. Only for the suspicion, they have only thing that they might have killed the disease, Lordship.
How many days now?
97. 97.
Pardon, Mr. President, counsel for listen. This is an application under students.
And charges are partly submitted, limited submitted.
Paragraph 2 of the bail. The case has already been partiated. However, perusal of material, perusal of the CD, as well as the certified copies of the statements of the witnesses submitted by learned counsel for the petition, it appears that there is no specific material against the present petitioners. And the case seems to be based on suspicion. Now, in the meantime, the petitioners have spent 97 days in custody. Having regard to the for bail 20,000 once.
Payment. Also, here, madam, we have annexed the 207 copy. 207 copies given to us. Now,
Okay.
madam, that
All right. Certified
now
copies,
230 BNL.
copies of, let's say copies
Yes.
of this.
Yes, much of it.
Lordship, allegation is under section 309, subsection 4 of BS. Lordship will find FIR at page 9. Basic allegation is regarding snatching of a gold.
So who are you?
I'm not the FIR name accused person.
Why are you here in the first place? Nobody has been named in the FIR.
Yes,
Why are you here?
But Lordship may kindly peruse para 5 of my petition, where I have mentioned that The petitioners were arrested in a different case, that is Fatasi Lambari PS case number 131 of 25. But later on, investigating officer of the instant case has made a prayer for shown arrest in the instant case. As such, production warrant was issued in the matter on 3/10/25, but before that, the petitions were granted. So at present, they are apprehended.
Okay, CD. Give it.
Acha.
Rightly. So, my lord, this epic was filed, my lord, on merit, my lord. But in the meantime, my lord, 7 years is almost completed, my lord. Therefore, petitioner is not, my lord, inclined to, my lord, go on merit. But here in this judgment, my lord, there is a my lord, error apparent on the face of it, my lord. Here, my lord, he is, my lord, so long he was in, my lord, womb, my lord, during trial. That was not set off, my lord.
There was an order that it will be taken up at the time of final hearing, then
Lordship,
how is it?
matter may be fixed for hearing, Lordship.
Lordship,
Paper book is ready, Lordship.
No, because the earlier order says so itself.
yes, my lord, just,
Yes,
my lord,
Lordship.
Lordship, kindly, my lord, prima facie, Lordship, one page, my lord, 198, my lord. This, the order, my lord, there is no provision even for set off, my lord. And 7 years will be completed in just January, my lord. Since, my lord, his first arrest, my lord, is in the home, my lord. In the appeal memo, my lord, 198, my lord. Page 198.
Appeal memo.
And otherwise, my lord, the provision of the law is very clear, my lord. Section 21, my lord, clearly says, my lord, after detention, some measure, my lord, he should be released on bail, or my lord, go to whom, my lord, after under observation, or he may be sent to jail, my lord. But in this way also, my lord, judgment.
I'm not following you. I do not know what is what in this
My
case
lord, in
at
the
all.
judgment, my lord, it was, my lord, 7 years, it was directed to stay in whom, my lord. But, my lord,
Juvenile.
juvenile, my lord.
Okay.
But so long he was in, my lord, whom, my lord, during trial, my lord, it was not set off, my lord.
So
Page 198,
excluding that 7 years, how long have you been in jail?
my lord, from his date of arrest, 19/1/2019, my lord, he was arrested. First, my lord, until he is in whom. Paragraph 72, my lord.
You are at home and you want suspension of sentence. But it's
Section 20, my lord, is clear, my lord.
yes, what does it say?
Now, at this stage, my instruction is that, my lord, he will complete, my lord, 7 years, but set off his provision should be there, my lord. Because judgment is passed only 2022.
So before that, he spent around
Yes, my lord.
3-4 years.
Yes, my lord. Since, my lord, 19/1/2019, my lord, my lord.
Which home he is in?
In whom, my lord?
Paper book.
Which one? Where?
Yes, Silchar, my lord, now, my lord. Observation home. And lordship, kindly may also look at, my lord, section 20. Section 20 is very clear at basic.
20 of?
My lord, this juvenile justice and care and protection.
Read.
Section 20, my lord.
Read.
Section 20 says that, my lord, the child attaining age of 21 years and yet to complete prescribed terms of stay in case of theft. When the child is complete with the law, attains the age of 21 years and is yet to complete the term of stay, the child's court shall provide for a follow-up by the probation officer or the district child protection unit or a social worker or by itself as required to evaluate if such child has undergone reformative changes and if the child can be of contributing member of the society, and for this purpose, the progress records of the child under subsection 4 of section 19 along with evaluation of the relevant expert are to be taken in consideration. After the completion of the procedure specified under subsection 1 of the child's court may decide to release the child on such condition as it deem fit, which includes appointment of a monitoring authority for the remainder of the prescribed term of stay. Roman 2, my lord, decide that the child shall complete the remainder of his term in a jail, provided that each state government shall maintain a list of monitoring authorities and monitoring procedure as may be prescribed. My lord. This part is also missing in the judgment. And my lord, this 19.
What is his age now?
Now, my lord, he is, my lord, 20. When he was arrested, my lord, he was 70 plus, my lord. 19 plus 70 plus, now 25, my lord. And in such case, my lord, I have a judgment, written judgment, my lord, considering law of the land, my lord, passed, my lord. He was, my lord, also entitled for bail also. Yes, This, my lord, January 19, my lord, will complete 7 years. But this section 20 is not spelled out in the judgment, my lord, and set off part is also not. But same judge, my lord, in the another, my lord, I have annexed, my lord, this another judgment of the same honorable judge, my lord, in the same court, my lord, subsequently passed, my lord, where set off is given, my lord. In my second, I
And if it is not mentioned, that is the law.
Yes,
It will off. By operation of law, it will be set off.
yes. It is a mandatory provision.
A very serious allegation, Lordship. Let the matter heard entirely, Lord.
My lord, there is for my lord hearing.
No, Lordship.
First, I is my lord for bail. It was filed, my lord, along with.
The II is effectively disposed of actually, because the order is that it will be heard at the time of
But
final hearing.
that, my lord, he is not insisting on the merit, my lord. He is obliged to complete 7 years. Just set off part. That may be clarified. So everything is over now, my lord. 7 years.
But so you don't want the appeal to be heard on merits.
Not necessary, my lord. He instructed, my lord.
Achha.
RS depend.
So we only say that the period
Yes, ma'am.
undergone before the judgment will be set off.
Yes, ma'am.
That is good enough for you.
Yes, ma'am.
I put the informant. The case is a very serious case. We will only say set off. That is the law.
Then Lordship, the entire matter, only just I am referring the judgment part of the learned trial judge Lordship, page 172.
What is the purpose of your submission?
Lordship, regarding his, if the setup then 7 years, Lordship, that part, entire matter may be heard, Lordships. What is the use to keep the matter pending, Lordship?
Nobody is keeping it pending. We are disposing it off.
Entire matter, Lordship.
Yes, that is his instruction.
Is ready.
Not on merit, just that.
It will be treated as withdrawn basically. Because he has only 2-3 months to go. Whether the in appeal it is upheld or
Lordship, that earlier part, Lordship, the prior to judgment part, Lordship, paragraph 72 of the judgment, lordship, of this learned court below. Paper book, lordship, I think page
Which page of the judgment?
internal page 88, lordship, and or 225, lordship, the paper book. In the paper book, lordship, the convict Abdul Qayyum Bolbuya is sent to corrective home for 7 years for the offense of committing kidnapping of ransom and murder of a deaf and dumb boy, namely Jubair Ahmed Majumdar, and concealing the dead body of the deceased Jubair Ahmed Majumdar under section 364, 302, 201, 34 IPC. And after serving out the sentence, a report be placed before this court regarding behavior, conduct, and his mental health development during the period of detention, lordship.
Yes, that part is fine. We're not interfering with that part.
Lordship. And regarding that part, lordship, prior to judgment part, lordship,
See, he will be completing 7 years of detention.
lordship, not detention, he was in corrective, lordship.
Corrective home, that is also a detention. But he's
Same-
free to go and watch cricket matches.
Safer home, lord. Earlier, he was prior to the judgment, delivering the judgment, he was in, as per record of the LCR of the learned court below, he was in safer home, lordship, from
Safer home.
2009.
What is safer home?
Safer home means, lordship, a home where no such any disturbance, not like jail, lordship, or detention, whatever. Like a. So.
How is it different from a correction home?
Correction home, lordship, is a reformation.
Observation home?
Correction home is a reformative home, lordship.
Yes.
And safer reformative, only he was in reformative home since the date of judgment, that is the 2022, lordship. And prior to that, he was in safer home as per the learned court judgment, court below's record, lordship. I verified last occasion, lordship. On 1/7/2019, produced from safer home. Then bail for CCL was rejected. Bail granted to CCL, but he failed to produce any guarantor. Then petition for relaxation of bail condition. CCL is failed to furnish bail bond. Accused on 6/7/2022, he was sent to jail, sentence order of the court as
Let us see the record.
lordship. I'll not, entire records may kindly produce, lordship. Perhaps on the day of commission of the crime, he was 17 years, months or 6 months, something like that, lordship.
Says place of safety, produced from place of safety. What is that place? Any record will not say whether that is a, that must be also a confinement.
Yes, my lord. The reformative, my lord, legit.
Now he is in observation home.
Yes, my lord.
Corrective,
So-
lordship. Corrective home, lordship, at Silchar, perhaps.
Is it called corrective home or observation home?
Corrective, as per order of the court, perhaps he is in the corrective home, lordship. At Silchar.
Whatever, he is in confinement basically.
my lord, reformatively, basically, take a person.
Yeah, those are homes where conditions are not like jail. They are,
Yes, my lord.
they are given some education, some
Yes,
training,
yes.
and
Always.
And the landed session judge also observed that the report be placed before the court regarding his behavior, conduct, and his mental.
that will be done after he completes.
Yes. So now the question is, Lordship, the prior trial period of
Yes, prior period, your contention is that period should not be counted.
Lordship.
Reason being that the place where he stayed is not the same as where he is staying now.
Yes.
So how is it not the same? It is for you to point out to the court.
So let me give Lordship some time, Lordship, to trace out this point, Lordship, whether earlier stay in of
All
stay of
right.
the accused.
Find out properly what is the
Lordship,
difference.
my duty is to assist your Lordship.
Another point, my lord, kindly, my lord.
PP also obtained the instruction. What the place
the-
where he stayed earlier, if there is any such distinction. Yes.
My lord, kindly just, my lord, another IA, my lord, page number 107, my lord. Same judge, my lord, same court, past order, my lord. Another different.
It is a different case, Lordship.
Not even, well, I am not against the conviction, just against, my lord, date of matter, my lord, just. Lordship 107, my lord, page, the IA, my lord. 918. Nicely, my lord, he has given the date of.
That must be adult.
Yes, but here it gives me.
Because of the
And my lord, set of provision is, my lord, mandatory, my lord, always shall be set off.
because of the facts and circumstances, case is Lordship itself, it was a very serious Lordship, very pathetic. Pathetic case,
That may be so. Now we are on the limited point. now.
Lordship. My learned
All right.
friend may take instruction on that, Lordship. I also trace the open point. Whether the prior conviction period safer home is same as character.
In criminal appeal 185 of 20. Learned counsel for the petitioner submits that the only relief sought for by the appellant at this stage is that the period of detention undergone by the appellant prior to the passing of the impugned judgment and sentence should be set off, as no such order is available in the impugned judgment. On the other hand, learned counsel appearing for the informant submits that the place of safety where the appellant had stayed prior to the passing of the judgment is not the same as the observation home or correction home where he has been placed after the passing of the judgment. However, at this stage, no such distinction could be pointed out by learned counsel for the informant, who prays for some more time to apprise the court in this regard. Full stop. Accordingly, is the matter again on
Friday. Friday.
Friday.
Lordship, she may take instruction, Lordship, from
Huh?
second.
Not Friday.
Let's have it on a Tuesday then. Tuesday.
Keep double.
Learned additional PP shall also obtain instructions in this regard and place it before the court on the next date fixed.
Much obliged, Lordship.
Obliged.
In the IA, you write in view of order first. And so please.
met with the loss. My lord, in this matter, it appears the respondent has entered appearance, my lord. So the matter may be posted for admission. And in this respect, I will pray before the house with the fixed.
You are
date, my
appearing for?
Acha, I'm appearing for respondent number 2 to 7 and 9 and 11.
What about others?
My lord, as per
I
the
have not
postal
entered.
information, my lord, all have received the notice, my lord, because your lordship can see paragraph 1 of my petition, page 4. Page 4, my lord. Paragraph 1 of my petition, and all have received, my lord. And they received long back on 19th of July 2025.
How did you serve them before
My-
filing?
My lord,
Paragraph?
paragraph 2 of my one of my petition, my page 4. That your lordship kindly see, respondent number 1 is the government, my lord. 2, 3, 4, 5 and 6, where the owners sold the land.
How does it prove that they have received notice of this case?
My lord, your lordship may please see this one, my lord. This is the postal notice, information that Mr. Asif, the respondent number 2, who is the land owner, my lord, and who has sold the land. In this respect, I beg to draw your lordship attention to paragraph 1 of my petition, the amendment I made. 2, 3.
Hardly legible.
My lord, kindly for lordship perusal, my lord. Respondent True is the main person, he is doing on behalf of all, my lord. Page After 7, all are family members, my lord. And 8, 9, 10, 11.
Would
they are-
not know that you file, if you want, on the basis of this, you can file an affidavit pointing out each of the respondents who have been served by way of this. We can't keep comparing one after the other. So many respondents are there. Yes.
For your lordship satisfaction, my lord, subject to correction, I wanted to draw your lordship attention to paragraph 1 of my petition.
We have already seen that.
My lord, 1 to 7 are all family members.
So what?
And
You have
rest
taken
are the
steps on all of them, haven't you?
my lord,
You had to take steps on all of them, even if they're family members, you have made them separately.
No, Lordship, I'm
Party
appearing
respondents.
on behalf of the respondent number 2 to 7
Yes.
and 9 and 11.
Yes, we understand. We are concerned with the rest.
9 and 11.
Now,
That
if
means
you-
only 10 is left, my lord.
Yes.
As per my learned friends, only 10 is
No,
left.
8, 9, 10.
Only 10.
8,
No,
8 also.
8, 9, 10. 9 you are appearing.
8 and 10. 12.
You are for 2 to 7,
2 to 7.
9 and 11.
9 and 11.
So 8 is left, 10 is left, and 12 is left.
12.
8, 10, 12. So does it show service on those respondents?
So on this, my lord, I will file affidavit as your lordship has.
Yes.
In the meantime,
At
Lordship,
learned
I will
counsel
file
to
my
the-
written objection.
I'd learn counsel for the petitioner, Mr. H.A. Ahmed has entered appearance on behalf of respondents number 227, 9 and 11. Full stop. As per office note dated 8/9/25, neither ID card nor any unserved notice in respect of respondents number 8, 10, and 12 have been received back. Full stop. It is submitted by learned counsel for the petitioner that the said respondents have been already served. According to you, they have been served.
Have been, sir.
Already been served, and
Sir, means my respondent number 2 have received on behalf of all because,
whatever you
yes,
to
I
say, you
will
say in
make
that affidavit.
mention of it.
And in this regard, a delivery manifest by the sub postmaster, Panjabari sub post office, Guwahati, has been furnished. Petitioner may file an affidavit explaining as to how service upon the said respondents number 8, 10, and 12 has been affected. List again on
And
in the meantime,
two for my lordship, maybe, may it be kindly be.
counter may be submitted, filed in respect of the respondents who have appeared.
It may be a bit shorter, my lord. I will file the affidavit at the earliest, because it is for our interest, my lord. Of-
What is the date you give? What is this application for?
This for I filed a petition before the tribunal, land grabbing tribunal, my petition, the Garnet has refused to take cognizance.
Not such an urgent matter. We have to give the staggered dates, can't just keep on preponing dates. Enough, file a detailed affidavit. Yes, next.
Lordship.
That,
I have filed my objection, my lord, against the IA for vacating my team stay order. That is probably not on record, my lord. If I have it, my lord, along with my lord objection, my. Any other date.
Which side? This is 1214 is here.
That is, in fact, my lord, I have filed this for continuation of my stay order because on the last date, my lord, on the basis of their statement that after stay order is there, my lord, and this is not displayed, then that is the responsibility of the council to, my lord, inform the registry. So in fact, that is not the correct, my lord, law that, my lord, that way, my lord, my interim order was not continued.
My lord, may I submit?
Yes.
Lord, I have filed petition for vacating of the stay order because, my lord, what happened?
That is the other IA.
Maintenance,
Yes, that is
IA,
other
my lord, IA 1030.
Yes.
So, my lord, my submission before your lordship is this.
Now, what are you, what was your submission regarding objection? Who is filing objection?
My lord, not objection, my lord, it is an IA.
Oh.
My learned will file an IA, praying that interim order may continue,
Yes.
not objection.
My affidavit also.
Your
I have
lordship would
filed
be
today.
pleased to
Yes,
take-
yours is 1030.
Yes,
on
1030.
vacating.
So, my lord, my humble submission before your lordship,
Yes.
that 4,000 rupees was granted by the court below. And for maintenance for 25,000, 2,500 for me, my lord, and for a side, 1,500, my lord. So, my lord, another 50,000 for compensation. But your lordships state that order is straightforward without considering anything. That was ex parte order. Now, my lord, my position is this, my lord. My child and myself, my lord, having no source of income. So, my lord, that stay order as a whole, my lord, it will be very difficult on my part, my lord.
Right, my lord, I have filed
And
my objection today,
another thing is this, my lord. Another thing is this. Actually, it is revisional court, my lord. My submission before your lordship, a revision has been filed against the judgment passed in appeal, my lord. So, my lord, my humble submission before your lordship, interference in revision against the appellate order, my lord. Its scope is limited, my lord. That is
Hear
the-
that part first. Let
lord.
us get the
My lord,
confusion cleared first.
my lord.
So basic fact is both are now merged. He is praying for continuance. You are praying for vacation
My
of
lord,
the stay order.
my lord.
But-
He want extension,
So it will be the same decision now.
my lord.
Whatever is the decision
My lord.
will affect both the cases.
Yes, both the side.
Yes.
Yes.
No, both the IAs,
Eh,
they can be disposed of by a common order. Either we continue or we vacate.
my lord, my lord. Let it be on record,
Either we continue or we vacate now at
Yes.
this stage.
my lord.
So that is what we need to hear.
A short date may be given, my lord. I am in suffering with my minor child, my lord. I have received the copy on 7/11/2020.
Hearing of the petition, main petition.
No, my lord, regarding vacation, my lord. That vacation, my lord, that I was filed on 9/9/2025. And it was listed on 29/10/2020.
Vacating the order would amount to deciding the revision itself actually.
Yes, yes, my lord.
Is it not?
Yes, my lord, there is some difference. Difference is this, my lord. Your lordship may consider that yes, you pay 50,000, 50% of the maintenance amount, 15% of the compensation amount, and then we will decide the case.
All right, we hear you want to file objection.
I have already filed today, my lord.
Okay, you
My lord,
It is not on
he
record probably.
filed, my lord, on 7/11/2025. One thing, your lordship, case was listed on 29/10/2025. So, my lord, I am suffering, my lord. But my learned friend taken 1 month about. Another 7-8 days to file this, and which is not on record. Now, my lord, a list date may be fixed, my lord, a short date may be given.
All right, IA 1030. Learned counsel for the petitioner as well as respondent. It is submitted that an objection has been filed by the respondent, which is not yet on record. Registry to place the same on record. List again on, give a date. Then IA number 1214. In view of order passed in IA number 1030 of 25 is the matter on.
An interim to continue, my lord.
No, my lord.
No, my lord, there is a settled law, my lord.
There is no meaning to any of this.
No,
If
my
you
lord.
say interim to continue,
will be
then we have
another
decided
problem,
it.
That will.
I am objecting, my lord.
In that way, I will be prejudiced, my lord.
No.
Because your lordship kindly allow me the one judgment of the apex court. That is the
So
judgment.
in
by
that case,
the-
we have to hear it.
No, that is only continuation of my interim order, my lord.
For that also you have filed an IA and he has the right to object.
If they may just file, they can file, but
They have
that
the
has
right
to be
object.
continued, my
Not
lord.
file, they can orally object also.
So, their objection is there, my lord, but the settled law is that it's not automatic, my lord, unless there is a reason order by the court vacating the interim order, my lord. That is the settled law, my lord. Not that, my lord, automatic, my lord. That is the law, my lord. This is by the constitution bench of the apex court. That interim order vacating is not automatic unless there is a reason order by the court.
That means there is no vacation.
No vacation, my lord. There has to be an order, my lord.
My submission,
If the interim, if that is the law,
Yes.
then your interim order
that
stands.
interim order will be
Yes.
unlimited period.
Not unlimited, my lord.
No,
Because since
That
second
cannot
date
be.
is subsequent date, your
that
lordship
cannot
will
be the
fix.
position of law,
So your
because my
lordship
lord,
has right-
your lordship passed the order, that 4 weeks interim order. Then otherwise, if it will continue beyond that period also automatically.
Anyway, we have fixed it on a short date,
No, your
so
lordship
there is no
kindly,
point.
if your
No,
lordship
my
will not
It is
consider.
only for payment of maintenance. If you don't pay, that will also be decided ultimately.
Yes, my lord. Your lordship kindly consider, my lord, that,
No,
my
my
lord.
lord, interim order
two
cannot be
paragraphs.
extended without hearing, my lord.
Two
My
paragraphs,
petition
my
is
lord.
there.
No, if we
It
have
is
to
the
pass
settled
order
law.
on your IA, we have to hear.
Yes.
We have to hear the matter.
It is the settled law date, my lord, unless there is a recent order
My
from the
lord,
court.
if my learned friend want to argue today itself, let us.
No, no, that is
Argue.
not what I
Let us
insist,
argue.
that is.
Why that
Yes.
extension?
Yes,
Kindly have just, my lord, 2 paragraphs of this constitution.
kindly
just
take your
made.
seat.
Yes, my lord.
Yeah, please, lordship, photo dated 10/11/25. Respondent number 4 and 5. And 3 lordship service not complete.
4 and 5. Rest have been served.
3 service not complete. Service.
Hmm?
3 service not complete.
So 3, 4 and 5 not served. Who is 1 and 2?
1 state.
State.
State. Lordship in charge.
Service on respondents number 3, 4 and 5 not complete as per office note dated 10/11/25. Await. Just again on.
Some lordship, some early date lordship. Early date.
How will service be complete by an early date?
May please, lordship, the criminal petition, lordship, the quashing the proceeding, lordship. Lordship, the both parties are amicably settled, lordship, the file affidavit. Information.
Yeah. You are appearing for 2.
Respondent two.
Yes, what happened now?
We have executed an affidavit.
Huh?
Executed an affidavit. We are not interested to run the proceeding because the victim got.
Then why don't you file an affidavit before this court?
Today I have filed.
You have filed,
Yes, Lord.
not on record. You submitted that an affidavit has been filed on behalf of respondent number 2, but the same is on record. Registry is directed to place the same on record by the next
Title.
date fixed. Please take in on.
Title, lordship.
Obliged.
May please, Your Lordship.
This matter was heard, my lord, on the last occasion. It was fixed for, my lord, by the prosecutor. Mainly, my lord, my argument was the non-compliance of 40 NDPS Act. Chain of custody was not non-being of the FSL report, non-examination of the bird.
I think as far as I remember, the FSL report itself was not exhibited.
Not exhibit. Not exhibit.
Yes, it was prosecution's turn to submission.
For this aspect, my lord, may kindly come to page number 44 of the, my lord, memo of appeal. My- Secondly, my lord, this is the, my lord, that it could application for suspension of sentence, my lord.
No, I think we are hearing the matter
Hearing the
finally.
main appeal.
Anyway, my lord, then my lord, may kindly come to, my lord, page number 44, my lord. Paragraph number 33, my lord. As far as the FSL report is concerned, it can be seen that by petition number 7670 dated 25/6/2024, learned defense counsel has stated that the evidence of forensic expert is not vital and the content of FSL report may be accepted. As per the FSL report dated 31/5/2023 rendered by Sri Syam Goswami, Senior Scientific Assistant, Drug and Narcotics Division, Directorate of Forensic Science, Assam, PN number so-and-so, gave positive test for codeine, present as codeine phosphate, and the amount of codeine phosphate was found to be 180.1 mg. It is to be mentioned herein that as per section 293 CRPC, the report of the expert can be accepted evidence by the court. That apart, prosecution has also exhibited Malkhana receipt as Exhibit W1, wherein it is stated that 1 carton of suspected narcotics drugs as per seizure list sealed and packed from SI Juntumuni Boisho is received and entered into Malkhana register by MR number so-and-so in connection with Sagolia OP GD entry number so-and-so dated 11/4/2023. The said Malkhana receipt was issued by Registrar of Gulakunj PS on 12/4/2023. That apart, the prosecution has also exhibited Exhibit P8 PW5, which was a prayer for in the Caesar list. The said prayer was made to learned Chief Judicial Magistrate Dubri, which was duly seen by Magistrate on 13/4/2023. Further, the certificate of correctness of inventory, photographs and samples of seized contraband was issued by the learned Judicial Magistrate on 18/4/2023. Moreover, as per the Caesar list, the correctness of the certificate issued by the learned magistrate forwarding report of the accused, the FIR and search sheet, there is a great uniformity regarding the number and name of syrup, which is 18 numbers of S-cup cup syrups. Moreover, the batch number so-and-so is also mentioned in the FIR. Forwarding of the accused in Caesar list. Further, in Malkhana receipt, Caesar list correctness of the certificate issued by the learned magistrate, there is a mention of MR number so-and-so. Therefore, there is a great degree of consistency as far as the chain of custody is concerned. No doubt, may be some discrepancy regarding the exact time of initiation of PW5. As per his cross-examination, he started investigation at 10:10 a.m. on 12/4/2023 between 10:10 a.m. till 12:45 p.m. On 12/4/2023, he visited the place of occurrence, recorded statement to witnesses as well as the informant. But the Ezhar the estate case was lodged on, this is regarding the, my lord, closing of the FIR and initiation of the investigation. As per the findings of the learned trial court, my lord, regarding the FSL, my lord, started from paragraph number 33, my lord.
Ultimately, it has to be exhibited by some or the other man. Yes, my lord, cannot say it was brought on record.
But it's not exhibited.
Yes, my
Once
lord.
it is exhibited, it becomes taken cognizance. Yeah. So examination of the expert may be dispensed with, but the language of, I think, 293, this has to be treated as evidence. If it is to be treated as
It accepted as
evidence,
evidence
then
by-
read into the evidence, then it has to be exhibited, subject to anything else.
Two 93 CRPC says, my lord, 93(1), my lord, reports of certain government scientific expert, any document purporting to be a report under the hand of a government scientific expert to whom this section applies upon any matter or thing duly submitted to him for examination or analysis and report steps, the course of any proceeding under this code may be used as evidence in an inquiry, trial, or other proceeding under this. So, my lord, as far as the 293(1) is concerned, my lord, that is clear, my lord.
No, it may be used as evidence, but what is the manner of tendering evidence? We are on that now.
FSL report is there, my lord. Go through, my lord, some judgment, my lord, regarding non-exhibit FSL. Whether it is the trial or amounts to acquittal in case of, my lord, narcotics drugs.
What were your other?
Other,
points?
my lord, if I have kept
I had taken the notes,
Yes.
but they have disappeared from the file, it seems. Somewhere else. Huh? Where are my
They have
notes?
also taken, my lord, probably, my lord, although I was not present on the last occasion, my lord. They have taken a point regarding section 42, my lord,
Yes,
non-compliance of
42.
section 42.
I can submit from the beginning. ma'am.
It may not be necessary to submit entirely from the beginning. You can just give me a,
Or I can submit a written note.
yes, written note, you
I
can, that
submit,
will be
ma'am.
clear. Not formal written arguments, just a
One
written
issue
note.
was the non-compliance of 40.
Yes, just to refresh my
Yes.
memory, you can just give the
Bullet
points.
I'll
And
submit the bullet.
as far as this 293 issue is concerned, if prosecution wants some time to find some
Fine.
judgments, let us have it on. By that time, you can also
My lord.
give it.
Let it come day after two.
Yeah, tomorrow we don't know how many matters we have fixed
You just submit the points, man.
on Tuesday.
18.
On the prayer of learned counsel, the petitioner as well as learned additional PP. Is the matter again on?
18. File you.
May I proceed? We have already prepared the written argument.
This was only for written arguments today. You were also supposed to submit judgments.
Yes, sir.
As per order dated 4/11/2025, written arguments have been submitted by learned counsel for the respondent, and the judgments have also been submitted by learned counsel for the petition. This is by you, petitioner. Bullet points. And this Delhi High Court by you.
Not. Is reference the code has been
All right. Errors have been mentioned. Keep the same on the record. And these judgments by you.
We have submitted two judgments.
Yes. All right, CV.
Thank you.
Okay, no, was there.
It was there.
Was there.